Participants, Rocky sir, good afternoon. Very warm welcome for today's workshop. The topic for today is turnaround and business rescue with an intent to prevent company from getting into the state of insolvency. Now, concerning the subject, may I say that financial distress faced by business entities is an age-old phenomena, and the kind of solution that would work best on it would invariably be dependent on the stage at which the financial distress gets recognized. Now, in the present uncertain times, entities do find themselves in financial distress very often. And in such instances, a company has a number of options at its disposal. And as I said, that it all depends at the stage at which the financial distress gets recognized. Now, the easiest and the most basic option ought to be turnaround. Turnaround strategies are applied by an entity whose current corporate and business level strategy is not working. And business rescue is a process which is employed by an entity seeking relief from creditors in a short term so as to recover from financial distress and be rehabilitated in the long run. Uh, for a successful business rescue, an entity would need to employ the services of a business rescue practitioner, and that's why we have named this workshop as kind of additional career opportunities for IPs. And so the professionals would in turn would need to equip themselves with a trained mind in terms of the strategy, the financial and the legal expertise that is required to guide the management of the company towards the path to recovery. And to enlighten us on these important crucial aspects, we have a very extremely learned faculty here with us, IP Rocky Ravinder Gupta sir. I will just take 1 minute or 2 minutes to briefly introduce her, and then I will request her to start the session. So, sir is an advocate, sir is an insolvency fellow, sir is also an accredited mediator, and most importantly, sir is an insolvency professional. To elaborate about the experience, sir has significant experience as a restructuring and insolvency lawyer and has been consulted by banks, insolvency practitioners, creditors, and debtors on different aspects related to the subject of restructuring, insolvency, workouts, banking and distressed debt transactions, and in a range of industries, including real estate, construction, mining, and manufacturing. Sir has also led a legal and commercial due diligence teams to facilitate decision-making process involving merger and acquisition transactions, stress asset management, debt management, and recovery. Sir has also advised companies and businesses on different aspects related to financial and operational restructuring and has also facilitated business rescue and turnaround. Now, with that, may I request Sir to start this session. Sir, over to you.
Good afternoon, everyone. Let me just put my PPT on the screen. Nitin, can you see the screen? It is
Yes, sir. Yes, sir. We can see it, sir.
Okay, very warm welcome to all of you. I have been a insolvency professional since 2018, and I have seen how IPs are struggling to finish up their cases or get the process in order. And the only thing that I was looking at is that how the IBC has been functioning since last 5 to 6 years. Most of the time, what we have seen is that since the inception of IBC, which was once touted as a very ambitious economic legislation of India, with the hope that it would yield a shorter time frame for resolution and lower losses in recoveries of debt. So our topic here today is turnaround business rescue. I'll just get on with it. Regarding some information that I need to give you before we start off with this is that as of September 2022, 23,417 applications were filed with NCLT, but they were resolved before even they got admitted. Total applications filed in NCLT might be somewhere around 27,000 to 28,000. So looking at this statistics, what we can look at is people are ready to settle the matter before even they get into IBC. Going ahead, that financial creditors realized 2.53 lakh crores from 612 cases under CRP, which actually translates into a huge haircut of 70%, approximately. It is 69.6% actually for banks and the financial institutions. Till December 2022, 1901 CRPs ended in liquidation, and out of those 243 liquidations were closed by dissolution, 20 by going concern sale, and 9 by compromise or agreement. Again, 9 were compromised or some sort of an agreement was reached. Speedy resolution is preferred under IBC. Delays not only erode the value of the asset, but gave a lot of haircuts to the creditors. The resolution process, if not taken care of properly, would eventually lead into liquidation. A very candid topic that comes up is about the judicial infrastructure that we have in India. You all know everything about how the system is working, and the time taken to adjudicate on disputes and conflicts is growing by every day, which actually results in depreciating the assets of the debtor and reduced payments to the creditors. Now, when we see at the global scenario, what's happening? We're looking at a looming recession. This fact has been confirmed by the IMF as well as the CBRC. We are at the cusp of a big looming recession in 2023. So this recession has been coming up because of various factors. The first being the Russian-Ukrainian war. If you see that normally the interest rates are increased when there is high inflation, and US Fed have increased rate by almost many times, almost 7 times in the last 1 year time. And you're aware that RBI too has increased their repo rates many times. The rising interest rates and the scaling back of the government support in terms of the COVID support that was given to the business has already been taken back. We have seen rising insolvency filings globally. The sectors which are being affected are real estate, hospitality, healthcare, financial services, logistics, manufacturing, which are supposed to get more affected in the next 1 year or so. So do we wait for financial stress to hit any sort of a business? Do we wait for the company to get into some sort of a negative cash flow where their back is against the wall and the only option left before them is to go for insolvency? We need something which is having a parallel approach through some sort of a restructuring, some sort of out-of-court settlements, probably through negotiations or conducting mediations between debtors and creditors, which should be institutionalized within the IBC itself. If you would remember that last month a discussion paper had come out of IBBI regarding the changes being thought about to bring in the IBC code, and a couple of them were regarding the fast track insolvency and the pre-packs. And one of the suggestions that we gave in the fast track amendments which are being made is almost similar to pre-pack solutions. So why not make fast track something on the lines of a settlement or a negotiations between debtor and creditors, where the courts have a minimum role to play in the whole process. So these suggestions have been made to IBBI. Now, if I can quote Mr. Sahu, who, while he was the chairman of IBBI, he said that in the long run, the best use of IBC would be to not use it at all. And that would be the ultimate corporate governance. So Mr. Sau also thought that IBC was only the last resort for a company in term when it is into a financial distress. But why are we in this situation? When I say time is of essence, everybody understands that. Why is there is a lot of issues with the timelines that we had within the IBC? As we go into this discussion and into this PPT, we'll start understanding the issues that are being faced by the businesses, by the IPs, and by the courts as well as by the regulators. Effectively, we do not have a risky culture in India. When a company is getting into trouble, they look at lawyers, chartered accountants to help them out. But are these the right people to help them out? Lawyers look at the legal aspect, chartered accountants look at the financial aspects. The company secretaries probably would be looking at the compliance aspect. As an IP, you also have to face these challenges. When we come on to the MSMEs, they do not have the right sort of professionals to advise them and when to seek help. And when to seek help is very important when we talk about business rescues. Adjudication of CRP is time consuming. That is something which we'll have to wait on till the time we have a good adjudication process in place. The result of which is that the financial institutions have to bear steep haircuts, because as and when the timelines are not maintained, as the time passes, there is a destruction in the value of assets. And one of the other reasons being that when the COC takes place, the people who come into the COC for as representative of the creditors do not have the decision-making authority, and the timelines are still affected because of these reasons. When we talk about turnaround, what sort of statutory help that we get from the laws? Normally, they are one-time settlements. Everybody who are present here are either IPs or chartered accountants or lawyers, understand that one-time settlements are there, given by the banks to settle the matters. But are these one-time settlements help out the debtors or not? That is a big question. Then on Section 230 of the Companies Act, we talk about scheme of arrangements. Then the RBI has given prudential framework for resolution of stressed assets. This is something which is, I would say, is near to helping companies in distress when they get into a situation where they need a turnaround. Then we have pre-packs. April 4, 2021, pre-packs came into existence. Until date, only 2 cases have been admitted all over India. So we understand that pre-packs are not designed to be debtor friendly. Then we talk about workouts. Now, this is a very new term that you might be hearing from me, but it's a very common term in various other jurisdictions. So when we talk about workouts, what do you mean by workout? Everybody does workouts to keep healthy. So this term was coined to keep the businesses healthy. And workouts effectively or essentially means negotiating with the creditors to find a solution to a dispute or a conflict. And these results in restructuring and turnarounds of the businesses. I'll be using the word businesses and companies because our IBC only caters to legal entities, whereas there are many businesses who are not legal entities. Now, when we say that these are where there are many legal entities and businesses which are not being conducted as legal entities, gives us a big opportunity. There are 6.3 crores MSMEs in India, out of which 30 lakhs, approximately 30 lakhs are legal entities. And from the previous slide, we saw that almost a little less than 30,000 have filed for insolvency. That relates to almost 1% of the total legal entities in India. Now, if we use this formula of 1% of legal entities coming into insolvency, think about that the 6 crores MSMEs in India, what would they be going through? They do not have any access to exit through IBC. They only have exit through the old insolvency laws that we have, the Presidential Insolvency Acts and the other acts. So if we take 1% of that 6 crores, that translates to 6 lakh. That is the market that we're talking about, which can be taken care of by a turnaround professional to turn around those MSMEs in India. This is a big number that we're talking about. And if we say that the IBC has taken almost 6 years to reach that figure of 30,000, so within the next 6 years, we would have probably 6 lakh cases and a 1 lakh case per year on an average. And that is a big opportunity for all of you. There are being 4,200 IPs here. I think that's a very big opportunity. Now, why IPs? Why not lawyers? Why not chartered accountants? The simple reason and the fact being that all of us are well trained in terms of wearing all the 3 hats of a lawyer, accountant, and a management consultant. We are well trained to wear all these 3 hats and run a company. We need sector experts to help us out with that. But yes, a single person cannot do that, but a combination of people can always do that. We know the rules and regulations on how to keep the company as a going concern and get maximum out of the revenues. All of us have access to other professionals. Now, after 6 years, most of us understand why the company got into stress, or why it got into a financial stress or an operational stress. After getting into the company's primary issues, we understand that and we take care of those primary issues. All of us know how to deal with the various stakeholders, including the COC, operational creditors, financial creditors, the banks, even the regulators. How you give your services to a debtor as an IP or as an RP or as an advisor can well make or break a business, because you become the promoter, director, CEO of the company, and you have the power to run that company. You have the business acumen to run any business with the help of the promoters or sector domain experts, and then you can run the company and bring it around if you have the right sort of people with you, if you have right sort of knowledge, and you have the intent to get the business back into profits. Now, how can you help? When we are into a CRP situation, when we are into an IBC process of CRP, what we initially do is stabilize the business, analyze the critical issues that have caused those business to destabilize, create and implement an emergency response plan depending upon the issues in the situation, restructuring it, and returning to normal. That is the normal process that we follow, and that's the same process that we follow when we try and turn around a company or do a business rescue. So now we come to a very important factor that these days in Delhi we have winters, and in winters normally what happens is that if you're not very careful, we're not wearing proper clothes, we start getting some sort of a throat infection, right? So what do you do when you have a little bit of itch and a throat infection? To try to get some sort of medicines which your friends tell or doctors say, take Vicks or take some other throat pill which can help you out. If it is not a couple of days you might have fever, then you go to a doctor, probably doctor would check out your symptoms and probably hospitalize you or give you some over the counter drugs, and thereafter you would take the course and get well. Effectively, what I want to stress out that when a company gets into a distress, there is a disease which is affecting the company. That disease is there in the company, and it always shows symptoms of that. Those symptoms are called early warning signals. So as a human body shows symptoms of illness much prior to that illness, like a hitch in the throat or something like that, the same way when a business is under stress, it gives signals. And these signals are called early warning signals. Now, when we talk about financial institutions, most of the private sector and the public sector banks have this early warning systems in place to understand how the company is performing. Those early warning systems take care of the companies by taking financial reports on a quarterly or a half yearly or annual basis, and they take care of that. But the issue with the Indian banks, private or public, mostly with the public sector bank, they don't see those signals when they're coming out of those financial reports. They almost always ignores them. In one of a meeting with the RBI ED, I had put the same question to them, that why don't you take care of your companies which come to your public sector banks and you have a prior information about their financial status. And they just laughed it off, saying that we act as and when required. So they wait till the last moment and then act upon it. It is like simply saying that when you are very ill, then only you go to a doctor, and probably you are admitted to an ICU for further action by the doctors. Probably you get out of it, probably don't get out of it. You are more serious. But the point is that we need to take action before when these symptoms come up. So a turnaround professional is adept at understanding identification of the stress signal and taking corrective intervention at the right point in time. In COVID, while the COVID was on, we started one a not-for-profit organization called Early Warning India, and some people related to Early Warning India are sitting in this as participants, and I'll introduce you to one of them, Mr. Nilesh Desai. Mr. Nilesh, can you just put up your video? I think he's not here. I think he is left. Anyway, so Mr. Nilesh is our associate from Hyderabad, and he runs a company, a not-for-profit organization, which helps MSMEs in distress. And he has mastered the art of the Altman score. The Altman score is one matrix which can predict the insolvency of a business 2 years prior before it gets into insolvency. So we have mastered that Altman score, and we have been using it to help companies in distress. So during the COVID period, we started one organization, not-for-profit organization called Early Warning India, which helped companies, along with Mr. Desai, to get early warning signals identified and acted upon by a team of around 30-35 people across India. We started chapters in Chennai, Hyderabad, Bangalore, Chandigarh, Lucknow, and Jaipur. So this was a pilot project for us in the turnaround space. And the motto of that was adapt, innovate, and transform. We first adapt to the current situation in the company, do some innovation like getting some plan of action in place, and then transform the company. the main aim or objective was to help viable companies to survive, to promote an entrepreneurial culture and help recognize failure. Now, what do I mean by that? To help recognize failure. If you have read the history of Apple, right? Apple went into a state of insolvency at one given point in time. And it was Microsoft which held him with $150 million to get out of the state of insolvency. One of the other objective was to reduce economic losses for society, creditors, and entrepreneurs by helping non-viable company to close down quickly. This is very important, and most of the most of the promoters get very emotionally attached with their companies and they refuse to shut it down. This actually increases their losses. So you have to be very, very subjective in terms of understanding that whether a company is viable or not. To give bankrupt entrepreneurs a fresh start. So if a company gets into liquidation, what happens to it? The company dies. The promoters don't die. The promoters are there. Promoters have that experience. Promoters have that acumen to do the business again. Most of the companies that we see in the West, in US, some companies would have been insolvent or liquidated 2 or 3 times. Again, they have come up and become billionaires. So this sort of a culture we need to inculcate into the Indian mindset. Now, if one important thing I would like to tell you is that when you talk about turnarounds, what do you mean by a turnaround? It normally, the nomenclature would mean that a company which is in stress can be taken back to where it came from, to its normal business levels. It also means that a company who is doing a business is not into a financial stress, but needs to scale up its business. That's as well as turnaround. When we talk about startups have an idea. The promoters of the startup have an idea. They set up a company and they run their startups. Out of 198 startups go down. Why? One of the reasons is that they do not have the proper skills to run a company, which you people have. You have the legal aspect taken care of, you have the financial aspect taken care of, you have the management aspect taken care of. So this is one of the space where turnaround professionals can give their consultancy, advice, and help the startups achieve what they thought was the value in their idea. And this has been before I go ahead, the Early Warning India was set up on the lines of Early Warning Europe, which is an EU-funded project, a not-for-profit project, and they're big time helping out startups in their project called Rescue. It is RESCUWE. If you see it on the net, you can find that all those turnaround professionals are helping out startups in their initial days. Nileshji, can I introduce you to everyone? You are now back on. Nileshji, can
Rocky, you can go ahead. Rocky, you can go ahead.
Okay, Nileshji, thank you. Now, this is a slide on the insolvency timelines. This shows what is written in the IBC. The whole 330 days of it, from appointment of a IRP to public announcement, from a moratorium, for appointment of evaluator, for IM for a COC, invitation of EOI, and the final list of RA, and then approval of resolution plan, and until the 330 days. But are these timelines adhered to? A distressed asset is like an ice cube. I hope everyone can see on their screen the ice cube.
Yes, sir, we can see it.
Yeah, so let's see this video first. This is a very interesting video. So if ice cube is supposed to be a business, or the assets in the business, there is a deterioration in value. If you do not take action within a proper time, the asset will deteriorate and there would be nothing left after some time. So very importantly, one has to see that that ice cube doesn't melt out. It should be refreezed to save the value within the ice cube. So early intervention is always better. To catch the signals early is very important. We'll be taking you through all these, how to catch the signals, what is the process of a company which takes the journey from a healthy company to an insolvent company. We'll be coming to that. So if we catch the signals very early, the symptoms of the disease within the company very early, there is high probability of success. Early intervention can lead to corrective actions. Many options are available at that point in time to have different course of actions to rehabilitate the company. For example, at that point in time, if we catch those signals very early, probably your CIBIL score would be better, and then you can get more finances at that point in time to run the company properly. But mind you, this is just an example. I'll be contradicting myself a little bit later on. And more the delay in understanding or identifying those signals, the probability of success goes down. And this has been proven as per statistics. So the importance of I'm stressing on these early warning signals is because these are very important for any turnaround professional to understand. Prevention is always better than cure. So what we're talking about is a preventive measure, not a curative measure. Within the IBC, it would be a curative measure, but outside the IBC, before even a company gets into a stress or a default situation, it would be a preventive measure. Obviously, when a person is getting sick and the symptoms are shown early, he can take preventive measures faster and he has a head start to mitigate those risks. And like I said, it's easy to get finances in the early days when the financial stress is just showing up. Restructuring is easier, it's flexible. There are many options to go around that problem in different ways and manners. Restructuring can be done in secrecy. There is no public announcement. There is no stigma attached with the restructuring at that point in time. You can always retain clients, employees, and vendors. If you have handled CRPs, you would understand that people start leaving companies, vendors stop providing the raw materials or the other things that are required for that specific business, and the clients also start moving away to different other people. There is an easy debt restructuring. Working capital requirement can be taken care of at that point in time because nobody knows that what the status of the company at that point in time is. Fast decision making needs to be there and high motivation needs to be there so that those signals can be used to create some sort of a plan of action to help out the company in distress. So this is again, I'm showing you the timeline. This is where the early warning signal comes up. This is TD, that's time of default. Here, the time of filing. Here is the admission. And here the 330 days timeline. So once you understand that at this point in time, when the early warning signals start showing, this time frame could extend from 6 months to 2 years to 3 years, depending upon the sector, the state of the company. This is the time frame where the turnaround professionals would effectively work. They would also work here, and here. Like I said, 22,000 companies settled here after admission, but sorry, they settled here after filing, but before admission. But yes, you have again 25 to 30 days before you can settle the matter here before the COC is formed. So this is a very important factor to understand that you have almost 2 years to 6 months to do a turnaround of a company or get into a advisory job to help the company start some sort of a plan of action here. Why do companies fail? Most of you would have, I mean, this is a very simple example. If you have taken, say, 1,000 rupees from or 10,000 rupees from some of your friend, relative, or any person, and if you are not repaying them back, you stop taking their phone calls. This is a normal thing that happens. Probably you have given money and you have called the person who have taken the money, he would stop taking your phone call because he doesn't have the money. So there's a lack of effective communication. You need to understand that banks, financial institutions, or the operational creditors, if they are told the actual reason for not paying, they would be better off and they would be better, they would better understand your issues and try and help you out to get over those issues. But if you do not communicate, then a lot of thing comes into the brain of people and they start making mountains out of nothing. Lack of insight into real financial situation. Then a lot of MSMEs who do not have access to proper professional advice, they have weak financial information and control systems, they do not have checks and balances within their financial control systems. So at that point, this actually translates into a bad situation for them because they don't have that knowledge and communication from their professional advisors as to what is happening in the company, and they fail to understand and see the early warning signals here. Not enough efforts for an informal solution. The mindset is not there as of now. जब परेशानी आ जाएगी तब उसको देखेंगे. It's not the attitude we want. We want the attitude that we have already a plan of action set up before even a tragedy strikes us. So at any point in time when we see that there is some stress in the financial statements, immediately people should be called in to take care of that. Yeah, whenever you fall ill, you don't wait for a situation where you have to be taken to a hospital for that matter. So you try and talk to some doctors who can help you out before the body gets much more into a stress and hospitalization becomes necessary. Passive attitude of management and shareholders is very, very prevalent these days because of that those early warning signals are not taken care of by the management, and subsequently a plan of action cannot be effectively implemented. Speedy and adequate turnaround. If the mindset is there, people would always come out and say, yes, there is an issue. If they accept that issue, they would always come out and and be ready to take speedy action and help from people. But this mindset is not there in India as of today. Most of the people do not accept that fact. And that is one major issue that we have been facing across different sectors. And I'll be coming to that in a while. So why do businesses fail? We are talking about the companies first. Companies, I was talking about the leadership, the management, the mindset. But why do businesses fail? When we see this slide, I have actually categorized these into business characteristics, general environment, strategic management, industry, financial policy, and management and shareholders. Let's talk about the financial policy first. Like you said, management information system has to be very proper. The debt structure needs to be very proper. A little bit higher debt is some sort of a situation where it can screw up the company big time. Working capital, one of the main reasons for companies I don't know about India, but yes, where the statistics are actually recorded is over trading. Like I do not have working capital, but my business product is selling very good, so I take a lot of loans because I do not have that working capital and overtrade on that. And then the issue becomes that if there is a default in my payment in that supply chain, I'm unable to pay back my creditors, and that working capital issue becomes huge for me. If we talk about the business characteristic maturity, every business has a cycle which it has to go through from inception to maturity, and at that point in time the business starts going down unless there is an innovation into that business. When we talk about Sony, for that matter, Sony was making Walkmans. Thereafter, when the digital media came, they didn't they didn't innovate to that extent, and the Walkman died. Similar to the case of uh, I just forgot the name of the company. Kodak and Moser Bear. Kodak and Moser Bear. Moser Bear came into digital, but later on that also went into insolvency. Kodak was into making cameras, right? Kodak is nowhere. There are other companies which are making cameras and much better cameras. So the size of the companies also matter. Like Kodak was such a huge, big firm that they didn't know what the right hand was doing and the left hand was doing. They didn't know about that. So understanding the whole business of yours is very important. Regarding the general environment, when we talk, the economics plays a big part. We'll talk about this economics in a couple of next slides. Technology, yes. If you do not keep up with technology, your business is going to get hurt. You need to innovate constantly. When we in 90s, I used to have a computer. So by the time I used to buy the computer, 6 months, the technology used to change. It used to be Windows 97, then it became a much higher powerful the computer, and thereafter, I mean, every 6 months it was changing. Now it doesn't change that much because if I am right, there would be Intel i3, i5, and i7, which the clock size changes, but it doesn't affect us because the computing power is so high that I don't need the computing power to run my Excel sheets or Word documents or PDF documents. But at that point in time, the technology was going very fast. Politics plays an important role. In a recent case where everybody was, I'll not name the company, some sort of allegations were made and politics is happening there. Legal and social factors do affect the business as well. One of the examples that I would take is cinema. Cinema has been very, very important in terms of changing the social fabric of any sort of a country. If I remember correctly, we used to have one serial called Hum Log way back in 1980s, I think, late 80s or middle 80s. That had a very deep influence on changing the social fabric of the country. A documented fact is one serial came up in Mexico, which was documented to change the social fabric of Mexico in terms of families and keeping and joint families. It had a very higher impact on the social fabric like this. So these sort of things take care of changes within the business as well. When we talk about strategic management, marketing and sales, most of the companies do not have, I'm not talking about very big companies, I'm talking about MSMEs. So when we talk about MSMEs, marketing and sales, the marketing and sales is not very positive in the sense that they do not have right sort of people. When we talk about Bhushan Steel, when it went down, there were many people, many companies who had only one customer, that was Bhushan Steel. I had some clients who were just dealing with Bhushan Steel. And the moment Bhushan Steel went down, within 6 months to 1 year after Bhushan Steel went into insolvency, they also went into insolvency because they didn't have any other customer. Their marketing and sales were so bad that they were only relying on one company to provide them with total revenues. Corporate governance, the same case that I was talking about earlier, which I would not like to name. Uh, customer behavior, the industry, when we talk about the industry, customer behavior, very important that you innovate and you keep the customers with you so that the wheel of revenues keep on churning. You need to be aware what your competitors are doing, because once, if you're not aware of those, then like I said, Kodak went down. Industry life cycle I've already spoken about. Then you should have financials with you to help you out. If you have and these, all of these characteristics are interlinked. If you have good corporate governance, there would be finances to fund you. If you have bad corporate governance and it comes out in the public, obviously nobody's going to touch you with the long pole. So these are the basic reasons for a business to fall. So when we talk about turnarounds, we need to understand in depth, in detail about the reasons for why a business can fall. So this is the theory that we teach and train when we are talking about turnaround. So I just spoke about it in a very short way and very fast way, so that you understand that these are the things that are very important to understand when we're trying to identify the reasons behind the downfall of a company or a business. Now, there can be two sort of causes. One is internal causes. Internal causes are causes which are within the control of the company sometimes. External causes, I do not have any control over the external causes. The simple reason being that they are external in nature. They are created by some other parties, and I am not the cause of them. So there's poor management, inadequate financial control, poor working capital management, high costs. When I talk about high costs, one example that I can give is that one of my clients, rather a friend of mine, set up a company with almost 3 times the capex of a normal company that would have set up. So if it would have been 1x, he set up the company at 3 to 4x. At that point in time, the business was quite good, but in next 2 years' time, there was a credit crunch from the vendors, and at that point in time, he didn't have the working capital to take care of those increased credit cycles, and the company went down. So high cost can be an issue. Lack of marketing efforts, overtrading. I've just explained to you in the earlier slide. Big projects, Tata's acquired Chorus, and that didn't work out very well. This is one of the good examples of big projects where they couldn't control the projects, and they could not merge the projects together, and which bring us to the next point is acquisition. So that acquisitions went bad because they were so big projects, they couldn't control the management, the systems. They couldn't control those, and they went bad, and they had to exit that specific project. Financial policy. You may be a big company, you may be a small company, right? But you need to brainstorm every time that what is going to happen. I mean, you can just say that, for example, tomorrow if my revenue goes down, what do I do? So if you have a small plan of actions ready prior to even that event happening, probably you will be in a much better state to take a corrective action. So financial policy or an operational policy, or brainstorming on what can happen to a business on the historical facts of different companies can be a bullet point for your brainstorming session. And if you have done that, probably you will be in a much better state to create action as and when the event happens. if we do not have this brainstorming and some sort of prior plans to do this, there would always be an organizational inertia and confusion where everybody would be thinking on what to do, how to do it, when to do it. So these sort of brainstorming session and small plan of action in case of some sort of eventuality helps the companies to remain solvent and have that strength within them to take care of whatever is coming their way. When we talk about external causes, let's say policy changes within the government or a sector, competition, force majeure events. Can anybody tell me what is a force majeure event?
COVID.
COVID was not a force majeure event, sir. It has been ruled by Supreme Courts of many countries. It was not a force majeure event, but yes, earthquakes, floods, these are force majeure, which are God-created events. Changes in market demand, adverse movement in commodity prices. So all these things like policy changes. One example that policy change that I can give you is one case I was doing when I asked them about what happened to you and what was the reason for you to get into an insolvency situation. The promoters told me that the policy change of the government in the logistics sector made them spend 2 lakh of rupees per truck. They were a trucking company. So per truck, they spent 2 lakh of rupees and they had 1,500 trucks. So almost 30 crores was spent on shortening the truck. Right. So this is something which companies have to do it to adhere to the policy, but that, I mean, the cash flow is affected and that company actually went into insolvency. Let's get on to the next slide. Prevention is better than cure. It is always good to say prevention is better than cure, but do we have that sort of mindset in India? I don't think we have that mindset in India. We need to educate the businesses on realities of financial distress and business culture, that they should need to understand that, yes, you cannot be, I mean, if you talk about human psychology, can you be happy 100% of the time?
No.
So if there is day 100, I mean, if you're living in Norway and there is sunlight 6 months in a year, would you like it? I mean, nobody would like it. There has to be a plus and a minus. There has to be a yin and a yang. There has to be a good and a bad to appreciate good. So if everything is going to be happy, then you would not understand what happiness is, right? So everybody also should understand that the business would not run properly in the next, say, 10 years. There would be ups and downs. So you should be ready to take care of those ups and downs. Once they understand that, the people would be able to understand and better manage the crisis of conflict, because they understand that these things cannot be stable. The revenues cannot be stable over a long period of time. They would go up and down, and they need to be aware of that and understand that business works that way. This would also help them to avoid business in time, the business crisis in time, because once you are aware of the fact that this thing might happen to me and you have a plan of action ready with you, you can immediately initiate that plan of action when the time comes or when the crisis steps in. Use of negotiation and mediation encourages the parties to put more information on the table. Now, you would be thinking, why I'm putting this specific line here. So when there is an issue between a debtor and a creditor, what happens? Like I said, most of the people would stop communication. And that communication, when it is stopped, creates more issues. The negotiations must go on. But what if parties do not trust each other? It is better to get a mediator into the picture. The mediator would help both the parties resolve their issues. At least, even if he can't resolve the issues, he will bring them to a negotiating table and help them out. And one of the other alternative option, career options for IPs is being a mediator. We'll be having that session on the 28th of February, along with Mr. Amajit Singh Chandiok. He's a senior advocate. Everyone knows him. So we'll be having this conversation on 28th of February, on next Tuesday. So if we do all this, it keeps the business as a going concern. When we talk about mediation and negotiation, we talk about in contrast to a legal option. Legal option is an option where the courts take care of your rights. So for example, if I have taken 1,000 rupees from Nilesh ji and I am unable to pay him back, Nilesh ji would go to the court and file a recovery suit against me and get 1,000 rupees. But if I can initiate a mediation between me and Nilesh ji, and probably I tell Nilesh ji that, see, my business has gone down, I do not have money to pay you, but yes, I can pay you 600 or 500 rupees within next 1 month. But then you'll have to forego the next 500 rupees, because if you take me to the court, it will take you many years to settle the matter, and the interest you will be waiving off all those interest, because I'll not be in a position to pay you. So that makes Nilesh ji would think that, yes, if I get 500 rupees from him right now, probably I'll be in a much better situation if I get 1,500 rupees along with interest after 5 years. So mediation and negotiation help us to back out of a legal solution and get into a win-win situation for both the parties. And these things would be taken care of in the other segment. But yes, if there are 10 issues before an insolvency court, this is I'm saying because of the timeline processes. If there are 10 issues before the insolvency courts, and if out of those 10 issues, 5 or 6 issues can be taken care of by mediation, those issues, if there are bilateral issues and no court direction is required, if those can be taken care of by the mediation, probably 4 or 5 issues can be taken care of by the mediation, the insolvency court will only have 5 issues to adjudicate upon, and that will take lesser time, and probably the timelines within the CRP process can go down. So this is mediation we are putting into the insolvency somehow or the other, and the government is also thinking about it in terms of bringing mediation bill, which is actually in a limbo right now. We have the information that it would come up in March or April when the budget session starts again. But again, there are certain clauses in the mediation bill which are not in sync or in consonance with the insolvency code. And if we can prevent prevent these things from happening, we do not take care of, actually we do take care of the stigma associated with insolvency, because nobody comes to know about it. This is all confidential proceedings that we have on negotiation and mediation, or when we communicate with that creditor, nobody else knows about it. So once that thing happens and matters are settled, the conflict and disputes are settled bilaterally between the debtor and the creditor, nobody comes to know about it. Your client, your vendors, your employees, other stakeholders, probably other creditors as well. So once there's no stigma associated with what comes with the insolvency, and there is no reputational loss, and the goodwill remains there for you to take care of. Before we go ahead, Nitin, can we take a break for 5 minutes?
Please, sir. Please, yes.
So it is 4:05. So we reconvene at 4:10.
Sure, sir. Sure, sir.
Okay. Thank you.
આ ચાલુ કરી આપને મારું બ્લૂટૂથ.
Nitin, should we start?
Please, sir. Please, sir. So we can start it.
Oh,
Thank you. Thank you.
turnaround management. There has to be a turnaround situation followed by early warning signals. Those signals are the symptoms of a disease within a business. Understanding what are causing those symptoms, analyzing them, and taking corrective action. It is simply understanding what is the issue with the business. This is what I can summarize turnaround management is all about. When we talk about a preventive measure, we are talking about it as a managing tool for corporate distress. Turnaround for business and companies is something which is important in terms of not letting that company get into insolvency, saving them from the stigma of insolvency, saving them from issues that crop up when the CRP processes start. And the CRP processes, when you talk of the insolvency resolution process, they are almost similar all over the world, and stigma is there across the world. It is not that that stigma is not there in US or UK or Canada or Australia, but it is everywhere. Very importantly, we need to create a rescue culture in India. Without it, I don't think if and when the individual insolvency start, the courts would be inundated with so many matters that there would be a total collapse of the adjudication process. Imagine 30,000 matters being treated by 35 to 40 judges in NCLTC. Now, if this number goes 3 times to 4 times in the individual insolvency, whenever it comes and whenever it is notified, how can the adjudicating authorities take care of this? So, even before, like Mr. Sahu said, it has to be a last resort. So, a rescue culture needs to be inculcated into the Indian business mindset so that the system automatically takes care through turnarounds and business rescue, rehabilitating whatever issues there are with the business, rehabilitating that similar business, and not letting that business come into insolvency. Only those companies should get into insolvency who are not viable. They should get into insolvency. Otherwise, they should be turned around even before they reach a state of insolvency, or even before a default happens, or even if a default has happened within limited time frame of a quarter or 2 quarters, they should be turned around by the professionals so that the default is taken care of, or there is some sort of understanding between the debtor and a creditor. And if this thing starts, it would create a conducive environment for negotiations. If the creditors are also with the mindset, yes, we have to save our money, let's start negotiating with the debtor, probably without without decreasing my interest rate, I'll get all my money back. Probably I might need to give him a moratorium, help out on his cash flows, understand his issues, how can I help him though in those issues. And if that sort of a mindset happens, uh, I can tell you that India is going to thrive after that, because businesses will not go down. These sort of situations would also teach the promoters, directors, or the proprietorship person, or the partners of a company, to not to take uh, these issues of business defaults, financial issues, in a very normal way. But these are very serious issues wherein a business can die, they can lose their business, their companies would be affected, the families of the employees would be affected, the like in the Bhushan Steel case, all the families of the vendors who went insolvent, their employees, families, the children's, some had to go without food for many days, because at that point in time there was uh, pandemic across India and across the world. So these things matter, and these things should be taken care of before they become very big. Now we'll focus more on the advantages of a pre-insolvency workout. When we talk about workouts, we talk about negotiations between debtor and a creditor. We talk about understanding the core issues affecting that specific business. We talk about rehabilitating that business by some sort of a turnaround plan, or some sort of a plan which can take care of the issues that have cropped up within within that business, which has actually affected that business's viability. So when we talk about an informal workout, now this terminology comes from the fact that I am also helping out businesses in different jurisdictions, but in India we do not have an informal workout process, right? We normally have a formal workout processes across in many jurisdictions worldwide, but in India we do not have. We just have one-time settlement schemes, or the prudential framework under which the banks operate, or we have a scheme of arrangement which has a lot of court intervention, right? But we do not have something which I would like to have, I would like to uh, start in India, is that if so let's talk about something which I feel should be in India. So when we talk about debtor and a creditor, we talk about a loan. It might be a CC limit, it might be a term loan, it might be anything as a loan. When we talk about loans, what is a loan? There has to be a loan agreement, right? And it is a contract, by the way. A loan agreement is a contract. Any contract, if we talk about legalities, any contract can be amended, altered, or modified by the consent of both the parties. So why can't RBI allow that? If I have given money to someone, being a financial service provider, why can't I renegotiate that contract? Why can't I do that? Secondly, even if we want that RBI to be regulator of financial service providers, and if we want some court intervention through a insolvency process, why can't we have something on these lines, that if I have an issue with my creditor, I get into a negotiation with him. Once I get into a negotiation with him, there should be provisions which we have already suggested to within that discussion paper, that why don't we have some sort of a standstill period. For example, say Nitin, I have taken money from Nitin, right? And Nitin is a company, I am also a company. So we both go to the court and say, Your Lordship, we are getting into a standstill agreement wherein within 60 days, we should be talking to each other, negotiating to each other, And within those 60 days, no adversarial proceeding should be initiated against me, that is a debtor. There's nothing bad about it. Both the parties would negotiate. If we reach a settlement within 60 days, we tell the court, yes, we have reached a settlement. Probably there could be a provision of court accepting the settlement, putting an approval on that plan, because there is no one, it is between a bilateral issue and nothing has been, court doesn't have a reason to not to agree to that settlement. In case, and now this is something which is between a bilateral issue between a creditor and debtor. So if there are multiple creditors, there could be a multiple negotiations with multiple creditors. For example, if there are 3 creditors and 2 agree to my demand, 1 doesn't agree, then what happens? No, these things are an issue of convenience. So probably I give him the complete payment to him over a period of time and ask him to sign on a settlement agreement. So we are getting into now the difficult part of it. But the basic part was that why can't a debtor and a creditor sit together and sort out the differences? This is the basic part. Why do we have to get a lot of legalities involved into this? This is a contractual agreement, and if there's a contractual agreement, it can be modified by the consent of both the parties. And if that happens, there would be lesser issues within the framework of the IBC or the banking regulation. It should be something which should be dealt with by the courts as well as the regulator, but a very simple process, not making it very complicated in the sense that it should not be costly, it should not be time consuming, it should be simple negotiation between the debtor and a creditor. So this is what I was talking about when we were talking about flexibility and ease of adaptation. When we talk about a workout, we always talk about the informal workout. Informal work, the difference between an informal and a formal process is the formal is conducted by the certain statutory provisions, probably rules and regulation by subordinate legislation. An informal workout is something which comes out of some sort of a rule and regulation which are given by the central bank, that is the RBI in our case, that yes, you have the freedom to negotiate with the financial provider and modify, alter, or change the terms and conditions of your loan agreement. So an informal workout is a better option for us, so that before, if informal workout doesn't happen, the creditor would always have an option to go for a formal insolvency or a formal steps to be taken to take that debtor into some sort of arrangement, whichever it might be. It could be through SARFAESI, it could be through IBC, it could be through by any other statute that would empower it to go to the court. So when we talk about the timing issues, so like I said, we'll park this timing issue because there are the other slides also which would actually make you understand why the timing issues are important. We'll park this timing issue. Confidentiality. Like I said, it is something between the debtor and the creditor, so confidentiality is always there. The word would not get out, and there would be less stigma than formal insolvency because nobody knows about it. There would be the debtor's business would be going as a would be working as a going concern without any stigma or a loss in goodwill. Like I said, if you are not going to the court, it would not change the rights of the parties. The rights still remain and sustain there within that loan agreement. No court involvement is there in an informal workout situation. When we talk about lower costs, yes. If we talk about, I'll give you an example on this, on the lower costs. Everybody must have heard about the Lehman Brothers case. It was in 2008 that Lehman Brothers, a merchant banker and a big financier, went into insolvency. There were almost $300 billion or $350 billion at stake there. Probably more. The insolvencies were running in 16 jurisdictions worldwide. 85 cases were filed across the globe. They used mediation and negotiation to settle the claims. And do you know how much legal cost that was saved by them? It was to the tune of $4 billion. That is the amount of legal costs they saved by getting into mediation and negotiation. Now I want to speak about the cost of conflict. Just hear me out and let's have a discussion on this. I mean, I'm not saying that, I'll not be putting onus of any bad doings or wrongdoings on anyone, but this is my thought process that I'm just putting in front of you. What is cost of conflict? If I have to repay 100 rupees to a bank and I tell him, Mr. Banker, take 80 rupees from me, I'll give you 20 rupees over a period of time. Or take 50 rupees from me, I'll give you 50 rupees over 3 years period along with the interest. Would banker agree for that? Would any banker agree to this, my proposition? They will not. They will never ever do that. They would rather take me into insolvency and be happy taking 30 rupees of the value of my total assets after 3 to 4 years or 2 years or 3 years. Why is this happening? This is the cost of conflict. Earlier I was paying him 100% over a period of 2 years, but because they didn't want to put their careers online, they didn't accept that. Or they were not empowered to do that. Their seniors were not happy with this proposal. They would rather have me go through an insolvency process, have a court stamp on an order which would safeguard their positions in the bank or the financial institution. We need to have a mindset change that cost of conflict should remain low. At that point in time, if it would have said, okay, I'll pay you upfront 80 rupees, they should have accepted that offer after investigating my business. The cost of conflict would have been very less, 20 rupees at the max. When you go further, if you take me into insolvency, there would be lesser amount of money available, number one. Number two, there would be expenses involved with the bank would have to pay proportionately as on a pro rata basis on whatever the financial debt they are.
ऊपर इसका डायरी नंबर है क्या? ठीक है, thank you very much. Okay.
There is some noise coming in from someone. Anyway, so this is the cost of conflict we need to keep down, and this mindset change has to come within the financial community as well, because unnecessary litigation is being taken care of because the banks don't want to take the onus of settling the matter before they get into an insolvency situation. So this is very important. So some mindsets need to be changed, needs to change on an urgent basis, and the bank need to safeguard their employees. Okay, if you do this, you will be safeguarded. And mind you, this is all public money when we're talking about public sector banks. So if he didn't say
वो फाइल हो गया है, डायरी नंबर तुमको शेयर कर दिया है, पेटिशन जो बुक मार्किंग वाली
there is one person who is speaking. Can you just mute, please?
पेटिशन फाइल हो गया है.
Nitin, just see who is speaking.
डायरी नंबर शेयर कर दिया तुमको व्हाट्सएप में. और फाइनल पेटिशन बुक मार्किंग के साथ जो होता है ना.
Can you hear me, sir? Can you please keep your
I think it's Mr. Nishant
Gaurav is speaking.
मैं बता दूं.
Can you mute him?
मैं इसको भी शेयर कर देता हूं. बाय.
Nishant ji, please mute yourself.
So this is one aspect of the banking sector that I needed to highlight before you. This is public money, and if the bank says, I will not take your 80 rupees, but I will take 30 rupees when you get into insolvency, he is losing 50 rupees of the public. That mindset needs to change. and there is a lack of regulatory impact on while we're talking about the informal workouts. So what are the challenges that we would be facing when we talk about the pre-insolvency workouts? Lack of unanimity requirement. Now, when there are 2-3 creditors, like I said, multiple creditors, how is the situation going to be handled? Because then it would create some sort of a conflict. So those things need to be taken care of by some statutory provisions or some subordinate legislation. I'll tell you one interesting thing. In many jurisdictions, if you get into a workout, all avoidance actions are prohibited. Right? Now tell me one thing. If this happens in India, how many cases would get into a pre-insolvency workout? So this, we were having a discussion with one of the RBI EDs, and he was not very comfortable with these facts. Then availability of different remedies. So if there is SARFAESI available to a financial institution, they would probably go to that rather than coming up for a workout. But yes, there should be some sort of rules and regulations that they cannot get into a SARFAESI mode unless they have negotiated with the debtor. So at least give a chance to the debtor to negotiate or restructure themselves on certain lines. Whatever statutes that we have on restructuring do not require debtor's consent, neither the scheme of arrangement nor the prudential framework. So consent of debtor should be taken. Fewer chances of lender's liability action. So this actually is a foreign concept, not applicable in India as of now, because this is basically when the lenders start running the debtor's business and they don't run it properly, then their liability comes up and they would be liable for whatever losses they might have occurred while running the debtor's business. So this is not applicable in India. Difficulties of multi-party negotiations that we've already spoken. Director's liability. How many of you understand director's liability? This is one concept which is very much required in India. When we talk about early warning signal, who is the first person to know that a company is getting insolvent? Anyone? Who is the first person to know the company is getting insolvent?
Promoter, sir.
Exactly. So it is the promoter or a director. Many developed jurisdictions have this director's liability, which states that when the business is getting into a state of insolvency, that is when those current assets goes lesser than the current liabilities. If I'm wrong, just correct me, because I'm not a chartered accountant, I'm a lawyer. So whatever I have got from the accounting part, I have probably read it from somewhere. So if the current assets are lesser than your current liabilities, you are in the state of insolvency. And if that state of insolvency continues for a month, the directors need to report it to their regulators. In our case, it would be MCA. Right. So this is the place, or this is the time when the person comes to know that they are into a state of insolvency and they report it to the regulator. The regulator informs the creditors and they start negotiating in an informal workout situation. We do not have that concept in India. It should be there. It has been proposed while the IBC was being drafted, but it was not put into that specific draft. Once this sort of liability comes into on the directors, you will see that a lot of informal workouts starts taking place. There would be creditors would be happy to settle the matter at that point in time. They would be happy to give a moratorium on a principal or the interest at that point in time, because they know the business is running good. For some reasons, it could the company is getting into a non-viable situation. So if they help them out, they would be getting more returns over a period of the next 5-6 years. The company works properly. So this is one area, and mind you, in, in many jurisdictions, if the directors don't report, there is penal action on that they could be jailed for not reporting this. So this is a very big area wherein directors' liability is sacrosanct, and they have to abide by all these. Existence of formal reorganization procedures. We have some, like I said, pre-packs, prudential framework, the scheme of arrangements, but these are not working quite well in India. There should be some other means and ways to bring about formal reorganization procedures in India. The obstacles to a formal workout or an informal workout across the world, multiple creditors. In some jurisdictions, I'm telling you all this because these concepts are already there across the globe. So if two creditors agree and their total debt is over 60% or 70%, depending upon the different jurisdiction, they can cram down upon the third creditor. That means that the third creditor would have to accept whatever the two creditors have agreed to. There's always a lack of trust between the debtor and the creditor if there is some sort of a default or some sort of interest not being paid in time, and there is a default, there's a lack of trust. And that's why we have suggested that mediation can bring that trust within the negotiation. Traders negotiate from a position of power. They would never back down and say, I don't want a 20% haircut. I don't want a 30% haircut. But they would be agreeable on a 70% haircut within an insolvency process. That is the mindset change I was talking about. The bank's culture, the same thing. Debtors lack of knowledge on mediation. So I was talking to, I will not name the meeting that I was in, but yes, it was a meeting with a lot of mediators in it. And in the Delhi High Court, when a mediation takes place, so the parties, when they come to mediation, they don't know what mediation is. They think of it as an arbitration, another legal process, which is going to take another year and a half, and they're not ready to come to the negotiating table. So that in the Delhi High Court, what they started was they started sending one leaflet with the summons of coming to the mediation. And when the people, and it was in a bilanguage, in English and Hindi, and it made a big effect on those people that they understood what mediation is, and they came to the mediation center, Delhi High Court Mediation Center, and agreed on having the mediation done, and at least having 2 sessions of mediation done. And it was a win-win for all. And as far as insolvency is concerned, we are in very nascent stages of getting mediation into insolvency. But this is going to be, in the next 2 to 3 years, you will see that mediation plays a very big role into insolvency. And that is why this is another career option for you to act as mediators, because you have the domain knowledge of insolvency. And if you get accreditation for as a mediator, this can be a great help to you in your career. Now, what is the turnaround situation? Now, see this video. Now assume that this bucket is your business and the revenue which is coming is this water. And these are the holes in the bucket which actually depicts the leakages within your business. Probably it could be a financial leakage or a manufacturing process leakage or any sort of a leakage. Employees might be siphoning off money. It could be anything. So these sort of leakages, inefficiencies within the business, these sort of leakages just take out the profits within the business and throw them out. Because of those leakages, the business cannot hold the profit within itself. And this is a very important visual that I'm showing you, that unless you fix up these leakages, you cannot help out the business. We'll come to this visual once again after some slides, which will actually tell you how to stop these leakages. This is what I was talking about the business cycle, that it starts from here, there's a growth, there's a maturity, it plateaus out here, and then the downfall begins. These red markers are the markers where we can do a turnaround and bring the business back to its normal way. And it would go, this is where the insolvency happens, and it can still go up from here, and it can still go after insolvency as well, it can be turned around. We have seen many businesses within the IBC also going back and as a going concern. So this is the life cycle of the business that I was talking about. And I didn't show you this slide earlier because now the interesting things are going to start, where you understand what are the various stages of a business downturn. Again, it is the same video, but now it has some caption on it. Please go through these captions and I will be explaining you these captions. The business is going through a strategic crisis right now. Then it goes into an earning crisis. And then the liquidity crisis. And then the CRP starts. CRP finishes. Still we are waiting here for education process to take place, to a resolution plan to hold, and the asset is going down in value. This is what actually is happening here. We need to stop this. We need to understand why these things are happening. How do we control them? So this is a chart or a graph of the journey of a company from a healthy company to an insolvent company. This is the total curve that you are seeing. So there are 3 stages during this journey of a company from a healthy company to insolvency company. First, it passes through a strategic crisis, then an earning crisis, and then the liquidity crisis. If we talk about how do we take care of them, this is where the early warning signals would come up. The warning signals would be coming up till the liquidity crisis. They would be similar in nature. खांसी बढ़ गई तो वो नीचे आएगी, हल्की सी खिचकिच हुई तो यहाँ पर आएगी. So between the strategic crisis and earning crisis, there is a decline. And between the earning crisis and liquidity crisis, there would be a distress. And then there would be a failure. So just listen to me. This is very interesting. And this is based upon some surveys, some sort of actual real life scenarios that have been taken into account before this theory was written. And this theory was written by one of my good friends, Jan, who's a professor and head of restructuring and insolvency at the Leiden University in Netherlands. So when the company is healthy, if you have interacted with the people who are running the company when the company is healthy, or between somewhere around here, you would find that there is a huge pride in the promoters. In this stage, the promoters are blinded by success. Their pride makes them believe that they are too big to fail. They fail to pay attention to and recognize the internal and external conditions which are changing in the environment. There are symptoms coming out from here, but they fail to recognize them. Like I told you about the Sony Walkman, they failed to recognize the signal that now this is time to change and innovate. In this stage, companies are not scanning their external environment. Even if they're scanning the external environment, they do not recognize the changes. They don't recognize the early warning signals or the symptoms of the business distress. They don't understand that and they fail to act upon it. The business continually keeps operating within the context of that external environment. The ability to understand and to adapt to the changing environment could mean the difference between a success and a failure. So if they understand this here, it is easy for them to correct whatever is happening. The pride doesn't let them see this. And I have spoken to hundreds of promoters, and the only thing that they tell me is that you don't know shit about my business. And I have been doing this business for 40 years. How can you come and advise me on how to do business? This is exactly the line I'm telling you that one of the promoters told me, and it is given to me in different ways and means by all the promoters, but the gist is always the same. So the early warning symptoms have come up here. They are unable to see it. The business is again going down the curve. They are unable to see it because the pride of the promoters stops them from seeing this. Now the earning crisis had two stages. One is of inaction. Because of their pride, they refuse to see this. Companies going on as such in its normal course because sometimes the organization is very large, or if the organization is small, they do not. If the organization is large, it is difficult for them to spot these early warning signals. And if an organization is small, they do not have the professional communication. By professional communication, I mean the financial communication or the legal communication, the financial statements or the legal documents. They are unable to understand those documents, and they are therefore fail to identify these early warning signals. They do not recognize it, and there is complete inaction till this place. And even if they find the early warning signals, or they identify those early warning signals, and it becomes apparent to them that yes, now there is some issue with the company, they do not have the wherewithal to take a correct action. They would be talking to people who do not understand this professional line of turnaround. They talk to their friends, relatives, to their lawyer, to their chartered accountant, who are not capable to understand these things. So the incorrect decisions would follow thereafter. Because if you take an advice which is not from perspective of rehabilitation or a rescue or a turnaround, it is an advice of a lawyer on a legal aspect, from a chartered accountant on a financial aspect, or from a company secretary on a compliance aspect. That doesn't help him. It only helps that specific advisory which is coming on a very narrow vision, probably, right? So the incorrect action would not help the company at all. The managers would try to make small changes, and at this point in time, what is the best part that you can do is cut costs, right? This is a normal process that people start cutting costs. They start paying less to the employees. They probably have a better increased credit cycles for their vendors. They would like to reduce the credit cycle from the money that they're going to receive from people. So this is they're trying to just increase their cash flows to get out of the situation. They're not trying to close that holes, which I showed you in the earlier slide. The money keeps on flowing out of those holes, and unless those holes are fixed, the money would not stay in the bucket. The next stage is called the liquidity crisis stage. This is because the company is unable to salvage itself from the strategic crisis, earning crisis stage. And their economic problem, their cash flow problems starts getting worse day by day. This is where it becomes apparent to the company that survival is difficult at this point in time, somewhere around here. But at this point in time, either they're cutting costs here or borrowing money from their friend, relative, or financial institution. They have done all those things. Now nobody is ready to give them money here. At this point in time, the failure would start setting into the company. This is where the promoter would just put up his hands and starts praying to the God. A lot of cutbacks would be there, layoffs would be there, and the company employees would be going towards greener pastures. If it is a service industry, the service would be not taken care of very well by the promoters, or if it is a manufacturing process, there would be some issues with the product itself, because there would be shortage of raw material, there would be shortage of a lot of other things, that the business would not be running properly. And this would ultimately lead to a default. Default can happen here as well, but this is where we think the default should happen, because now nobody is giving them the money. And then the insolvency would happen, and ultimately there would be a liquidation of the company. This is where we think that people should be aware how to handle this thing. And my take on this is that as an IP or as a turnaround professional, you can work here, you can work till here, you can work till here, you can still take back the company and keep it as a going concern, you can work till here, and you can work till here. After insolvency, what happens is that the promoters or directors get into some sort of a depression. Here also, as a chartered accountant, I'm not saying that as an IP, you can help the promoter understand the nitty-gritties of insolvency and help him get out of the depression and face the insolvency up and square, so that he has the motivation to go ahead with the bankruptcy or insolvency and get out of it and start a new company thereafter. So this is where we can actually help the companies out completely at any time in the whole process. So, like I told you about the early warning India, one of the major thing that what happens is that when you are talking to any person or a company or a business owner, has anyone ever come to you in the initial stages and asked you, what should I do? I am having this problem. Nobody comes out and tells anyone about this. So what we did was, we were having one in the initial stages of when we started early warning India. And this is a completely not pro bono exercise that we were doing in the pandemic, that we were addressing some people in Rewari, and they were all industrialists, and they had come to attend this turnaround session, and nobody said anything. We gave them a presentation, that we are here to help you out, but nobody came to us. Nobody, not a single person came to us. So we thought that there is some issue with what we are saying, or there is some issue with our presentation, and ultimately we reached a conclusion that people don't want to talk about their problem in public. Nobody wants to say that my company is going bust in public. It affects its reputation, goodwill, and there's a stigma attached with it. So we created one tool so that nobody knows what the other person is thinking. What we did was we created one Google or a Microsoft page where we listed out 20 questions for them. And these are the 20 questions. And mind you, we are only meeting this person for the first time. I do not have access to his financial statements. I do not have access to what he does. I do not have any knowledge of how old is he, what is his work experience. I don't have any knowledge about him. I'm just meeting a person. I've given him this page to answer it in a yes or no. He need not give his name, address, email. We ask for that, but it is not necessary for him. He can put anything in that, and he needs to answer these 20 important questions. So these are spending most of the time preventing problems from escalating. You have received a recovery notice. You have little day-to-day knowledge of accounts, delay in filing tax return, GST and other compliances. Net current assets are less than your current liability. You're getting constant reminders or demands for payment from your creditors. Your customers are complaining more than usual. Average time of repayment of debt is increasing. So he has to answer all these questions in yes and no. So all these 4 or 20 questions need to be answered. Once he answers those questions, I'll go back till here. So a score is generated, and that score is only known to him. Mind you, he's doing this exercise on his notebook or on his phone or on his laptop. So when the score is generated, say he scores somewhere around 100. So he would be somewhere in this stage. 90 to 100 would be somewhere in this stage. Then 70 to 90 would be somewhere in this stage. 40 to 70 would be somewhere in this stage. And 40 or less would be here. So this way we started understanding, and this is completely objective determination of a person's business viability. I'm not saying that we would be wrong, sure 100% of the time, but yes, this is an objective test probably, and it makes him understand that he's doing a lot of wrong things. So the phases of downturn is that early warning signals need to be identified, otherwise they would be declined, they would be distress or a failure. And like I said, the promoters or the directors, they don't think there is a problem ever till the time it is staring right in their face. They do think there's a problem, but hope things will just get better on their own. They know there is a problem, but they don't want to face it. This is exactly you will face if you talk to any promoter about issues within their business. And once we overcome this challenge, he would be definitely understanding what you are going to say to him. So basically, we're talking about crisis denial when a promoter refuses to understand that. There's a hidden crisis there, but he doesn't want to see it, he doesn't want to face it. The disintegration of the organization begins, some action taken, but need for action underestimated. The action taken might be infusion of funds into the business or the company. And mind you, every time a person comes and sees me for advice, the first thing that he asks me, I'm talking to you about 100% of the time. If any person, promoter is facing difficulty, the one thing that he would come and ask me is, sir, paise dilwa do, funding karwa do mere ko. Get me some funds, my business would stabilize. I hope I think you must have all gone through this. That anybody coming to you with an issue in their business would always be asking for funds,
Yes, sir.
Yes, sir.
and never give him the funds. Never ever say to him that we'll give you the funds, because remember that bucket with holes. The more funds you put into that bucket, the leakages would always remove that fund from that bucket.
Yes, sir. One
Always.
thing, sir, how to generate the score, which you have just said right now.
I will tell you. You can go to this website. If you go to earlymorningindia.org, on the top hand, you will find a panel where you can just click and it will be taken directly to that page, right?
Okay, right, sir. Thank you, sir. It's your company?
No, this is our not-for-profit
Voluntary.
organization.
Right, sir. Thank you. So please share this PPT so that we can.
No, this PPT is actually copyrighted,
Once more.
right?
Okay.
We can
Once again.
this is earlymorningindia.org.
If you could go to the previous slide, we would take a screenshot. Thank you.
So after disintegration, there is an organizational collapse. After that, there could be a recovery or a failure. And if you see the IBC statistics, 70% of time there is a failure, 70 to 80% of time. 20% of time there would be recovery. So at this stage, the recovery is, there would be 80% chance of recovery. As you come down, the chances of recovery goes down. Now, when you come to workouts, there are some principles of workouts which have been published by Insol International, by the World Bank, and through UNISTRAL. UNISTRAL is a body of UN which takes care of all these things in terms of the cross-border insolvency, the model law, the legislative guide. India's IBC code is based upon that legislative guide, right? Most of the countries use that legislative guide to draft their insolvency laws. So this, they gave out a principles for a global approach to multi-creditor workout. This was the second time they have sent it out. They have modified it. Earlier it was given around 20 years back. Now they have given it out, I don't know the year in which, but it came out 7-8 years back. So this workout has some principles attached to it, which should be put up into the various central banks, subordinate legislations to help out the workout in the financial field. The first principle, this is not something which is specific to India, but this you should know, because these are the things which are going to come up in the future in India. And probably, I'm not very sure, but probably this might be one of the changes which are going to come up in the next IBC amendments. Probably, I am not very sure. So when a debtor is found to be in financial difficulties, all relevant creditors should be prepared to cooperate with each other to give sufficient time, standstill period, like I said, about 30 to 60 days of period, to the debtor for information about debtor to be obtained and evaluated, and for proposals for resolving the debtor's financial difficulties to be formulated and assessed, unless such course is inappropriate in a particular case. And that case would be if some fraud has been committed, or that fraud has come to the knowledge of the creditor. So effectively what it says is that let debtor and creditor decide what needs to be done. No regulator needs to come in between as of this stage. During the standstill period, all relevant creditors should agree to refrain from taking any steps to enforce their claims against or otherwise than by disposal of the debt to a third party to reduce their exposure to the debtor, but are entitled to expect that during the standstill period, their position relative to other creditors and each other will not be prejudiced. Conflicts of interest in the creditor group should be identified early and dealt with appropriately. Effectively, what this says is that all relevant could refrain from taking any adversarial action. During the standstill period, the debtor should not take any action which might adversely affect the prospective return to relevant creditors. Interest of relevant creditors are best served by coordinating the response to a debtor in financial difficulty. This is the mindset that we need to get into the Indian banking system. Recovery of money should not be the main objective. The main objective should be to how to keep the debtor's business as a going concern. Because if that concern keeps on going, there would be multiple gains to the financial creditor. During the standstill period, the debtor should provide and allow relevant creditors or their professional advisors reasonable and timely access to all relevant information relating to its assets, liabilities, business, and prospects in order to enable proper evaluation to be made of its financial position. Effectively, creditors should be called, a data room should be made ready for them to evaluate that whatever debtor is saying is correct or not. If it is correct, they should provide him with some assistance so that he can keep his business up and running, keep it as a going concern, and use that business again to repay the creditor. Probably not in 2 years' time, probably in 3 years' time. Proposal for resolving the financial difficulties of debtor and so far as practicable arrangement between relevant creditors relating to any standstill should reflect applicable law and the relative position of relevant creditors at the standstill commencement date. This is something which is theory for us, nothing in practice in India. So let's leave it at that. It is asking for some sort of a subordinate legislation or a statutory rules and regulations for this thing to take effect. Information obtained for the purpose of the process concerning the assets liabilities should be made available to all relevant creditors and should be treated as confidential. This is where the issue would start. Problem here in India that would I can foresee is that the creditors might use that specific confidential information against them in the court of law. So the Evidence Act would need to be changed that these confidential information cannot be used to initiate adversarial proceedings, be it civil proceedings or the criminal proceedings. If additional funding is required during the standstill period or under any rescue or restructuring proposal, the repayment of such additional funding should, so far as practical, be accorded priority status as compared to other indebtedness. It is similar to what we see when additional capital is given in the CRP, which is accorded priority status above all the it is the most CRP cost. As a CRP cost, it is taken up in the waterfall arrangement. So now this slide has been specifically put because of, like I told you, the negotiation and mediations are going to be very important in the coming years, and workouts would be the mainstay of negotiations between debtor and the creditors. So it should be as soon as possible. Identify the issues and the concern areas, identify the stakeholders who are responsible for this, and start negotiating and mediating. And why mediation? We will take up this on Tuesday, that why this is a win-win situation for everyone. There are no losers in mediation, there are always winners. Both sides come out winners in mediation. So this is a dispute redressal mechanism. It saves on time, it saves on cost, it's voluntary. Importantly, what mediation...
Sir, sorry to interrupt. Sir, you have said mediation and negotiation.
Yeah.
So you mean to say that all the creditors will be paid out in this process?
No, I'm not saying that. I'm not saying that.
Some part they will forego that.
No, I'm not saying even forego. I'm saying that
Okay.
depending upon the situation in a business, right? So if a creditor is saying that my EMI is 100 rupees, I say I cannot pay you 100 rupees because my cash flow doesn't allow me to pay you 100 rupees. If I pay you 100 rupees, I can't pay my vendors, right? I can pay you 80 rupees. 20 rupees would go towards my vendor. I'm not saying I'm not going to pay you back completely. I'm saying that reduce my EMI, increase my term,
Okay.
right?
Restructuring basically, replacement type.
Exactly. So what we are trying to do is, in today's time, when we go to a bank, he would say no. You say you will pay me 100. Don't pay me 100. Pay me 80. But in the restructuring agreement, I'll not write 80. This is what normally is happening in India, right? I don't want that. I want, okay, let's put it down at 80 so that effectively the restructuring process goes as per my cash flow, not per as what the bank thinks the cash flow should be.
Right, sir. Refacement of the loan basically, change in terms and conditions.
So this is a bilateral contractual agreement. Why can't we change it? If both the parties agree to it. And in mediation, like I said, it's a voluntary process. Me and you, if you want to get into a mediation, we can easily get into a mediation, and both of us are free to get out of that mediation before the settlement agreement happens. There is no binding, there is no force upon you to keep mediating. You don't want to mediate, you can get out of it.
But sir, this whole process requires funds because you said that current assets are less than the current liabilities. So it means debtors are less than the sundry creditors. So the party needs fund to pay off.
To pay off, no, we're not talking about pay, we're talking about restructuring.
Okay, in the coming years, you are saying that the company under this stress will pay off.
No, I'm saying that, see, if I can pay off, I am not in stress. I do not have assets to pay off, right? Even if you tell the creditor, okay, you take 80 rupees instead of 100 rupees from me, and as a one-time settlement, would they agree? They will never agree because there is no force of law behind it, right? So I'm saying that these sort of processes would be coming in the next year or so within India, so that these things become a actual possibility. So we are not dependent upon banks' whims and fancies. कि मैं ये कर सकता हूँ और मैं ये नहीं कर सकता हूँ because I am happy doing this, I am not happy doing that. It shouldn't be that way. It should be on a win-win situation for both the sides. And mediation helps to have a win-win situation for both the parties, because it is not the mediator. We'll be telling you about this on 28, but mediator is not a person who is going to settle that matter. Who's going to settle the matter in mediation? Tell me.
Sir, banks so generally go like there is a RBI policy on
Yes.
such type of companies which are under stress. In that cases, there is a replacement plan that banks consider for such accounts, and they agree for the refacement of the terms and conditions.
Yes.
But for the non-financial creditors, like which are not institutions, like individuals, there problem arises.
I agree with you. I'm just asking you, in a mediation, who is the party responsible for getting into a settlement?
And that CD, corporate debtor company itself.
No, it is both the creditor and the debtor.
Right, both. Because
both of them, mediator is not a party to that settlement agreement in the term that he is not forcing them to get into a settlement. It is both the parties who agree to a settlement on a terms and conditions that they both agree to. Mediator's role is not to get them into a settlement. His only role is to run the process of mediation. That's it.
Process to bring these party into some agreement.
To let them get into an agreement by themselves.
Right, to themselves, right. According to their own wishes.
Yes. So if both the parties come to a settlement agreement in mediation on their own wishes, then both are the winners there. I mean,
Litigation cost is saved and time is saved.
Yes,
And
yes, yeah,
that's why
yeah,
they are
exactly,
interested.
exactly.
Bank is also
Exactly.
interested and individuals also.
Yeah, yeah. So this is voluntary in nature. It's
Right.
completely confidential.
So this early warning India company is doing a mediation thing.
No, we're not doing mediation.
Okay, not doing mediation. Who are the mediators?
We'll come to that. Today is this turnaround thing. We're not. I'm just getting into mediation because put this slide so that you're aware that mediation. How does mediation work in insolvency? But there's a full session for that on mediation. Right.
Right. Okay, sir.
So mediation settlement agreement is confidential.
Mm-hmm.
Cannot be called even in the court of law to disclose what the settlement agreement is all about. Okay.
Right, sir. Understood.
It is flexible. It is flexible in the sense that it is the parties who come to an agreement. It can be modified, changed depending upon the situation. So it can go any way, and the parties are free to walk out of the mediation at any point in time. No question asked. Okay.
Okay, right, sir.
Sir, and who is going to appoint the IP as a mediator? Like it is in the hands of the corporate debtor or it is in the hands of the financial institution bankers?
Now we are getting into a sphere. Well, if I answer this question, it will take me 20 minutes.
Okay.
Right.
Sir, but it is very crucial question because, sir, we want to know like what is the future prospects of this mediation, like where we stand as an IP.
So let's you join this session on 28th Tuesday.
Okay. Yes,
right?
yes, sir.
Right?
Yes.
And the Mr. Chandiok, Amarjit Singh Chandiok sir hai. He is heading Madhyam. That's a mediation, complete mediation cell. It is working. So he'll be with us on Tuesday, and I'll be taking the session, and he'll be the expert advice. He'll start the session with his opening remarks. Okay.
Okay,
There's
sir.
one small query, sir.
Yeah.
Now we understood that turnaround can happen and how it will be happening. Wanted to know, promoters, they themselves will not come to us to get the work done or to get our services. Now we need to identify what are the companies which are under early warning signals or at each whatever stage of the default issues. Now, how to understand what are the companies which are under this particular stage?
Ma'am, this question has too many answers. The first answer to your question would be that first you need to have a certification for turnaround as a turnaround professional, right? The second part of your question is where do you get the clients from, right? This is your question.
Yes, yeah.
So actually, we are setting up another NGO specifically on turnaround, right? So we'll have a session on that later so that you can join in, and we will be putting public in knowledge of this fact that turnaround should be there. We'll be interacting with a lot of industrial associations, with a lot of chamber of commerces, with a lot of with business community at large, and tell them about this whole process. And thereafter, there would be queries coming in from a lot of people. We're getting queries as of now, but as of now, we do not have that capacity to handle so many queries. Okay. I am in Delhi NCR. I have an office in Gurgaon. We get almost 5 to 10 queries every day because of Early Morning India. Early Morning India is completely pro bono. We do not charge anything for our services. This was started in pandemic time, and at that time we thought it as a responsibility to help people in distress and companies in distress. So we had helped them. But yes, we are bringing in something commercial in nature on the lines of Early Morning India. Does this answer your question, ma'am?
Thank you, sir. We'll definitely look into Early Morning India website also, and also.
Yeah, please. You will find a lot of material there. And we are in, we have set this up with Early Morning Europe. And if you can go to Early Morning Europe's website, you'll find a lot of material there. And Morten Moller, who is heading that network of early morning systems in Europe, which is around in 19 to 20 countries in Europe, even in Mexico and Brazil, they have started it. So Morten Moller is the coordinator for all these systems across Europe. So he's on our advisory committee in Early Morning India. So he's the person who helped us set up this whole thing in India. So let's see this, the key elements of successful turnaround. And we'll have a one question answer session after this end of PPT, which is going to be very soon now. There are 109 slides. I've only done 57, but I'll stop somewhere in between now. So you have to take control. You have to analyze it 360 degrees. There has to be a vision. As a turnaround professional, you should be able to see and visualize where do you want to take the company from, where is it today and where it is going to be tomorrow. There has to be a turnaround strategy. Next 2-3 slides would be on different turnaround strategies. Operational analysis and action plan. You have to do that as you do it in as a resolution professional in a company to keep that company running. Financial projections. All of you are CAs, you all understand that very well, more than me. Timelines, very important. Varna wo ice would always melt away and there would be nothing left. Risk and financial restructuring analysis. So this analysis is based upon how and what are the risks available. Risk management has to be there, mitigation of risks, and how that the risk would be mitigated as per the money available within the company, and the final plan of action. These are the key elements of successful turnaround. The key objectives: take control and manage the immediate crisis, rebuild stakeholder support, fix the business. By fixing the business, I mean closing all those holes which were in that bucket. Thereafter, you should look at the future funding. Normally, when the person comes, this funding they ask for in the first place, but it should be at the last. So these are the generic turnaround strategies. Crisis stabilization. So you need to take control. You need to take care of the cash management so that you're never in a negative cash flow situation. Probably you can sell off some assets, reduce them to create some cash flows. Short-term financing, if still there is some issues with cash, you can look at short-term financing. And this short-term financing would be available to you if you are very well in time. You have identified those signals. The promoters has agreed to hire you as a turnaround professional or a rescue professional, and this short-term financing would be available without any issues at that point in time. And the first step should be to try and reduce costs so that your cash flow is okay in terms of paying out vendors or getting in the money from your people from whom you have to take money. So next you need to see how your HR is performing, your leadership, how your CEO is performing, how your senior management is performing. Probably the CEO is not up to the mark. You need to change the CEO, because there are many factors involved when you're thinking about a loss-making business or a business which needs restructuring. What is the cause of it? So if the leadership is the cause, change the leadership. Stakeholder support, communication. Every part of turnaround would require communication somehow or the other with someone or some stakeholder or the other. Whatever be the case, communication needs to go on. The communication should not stop. After you've done all that, then you need to have focus on what the company was effectively doing, profitably doing. Redefine core business, Now you would have seen that the Tata Group has redefined its core business. It has sold out some businesses, is focusing on more on automobiles, more on IT industry. It has sold off its animal feed division. It has sold off some of its other divisions as well. Disinvestment and asset reduction is, for example, you want to sell off one division of yours which is useless and not making any profits. You want to sell it off. Then you also need to focus on your product. when Tata's bought into this JLR, they were not thinking about making profits out of JLR. They were thinking about making profits out of the new cars of Tatas that are coming in with better technology. Earlier, if you remember, Tata's Indica, there was the first car I think that they've made, which was one of my friends had it, and it was always going to the service station for some issue or the other. But now I don't have a Tata car, but what I hear from people is that a couple of my friends have Harrier, so they say it's a wonderful car. It doesn't have to, there are very less issues with it. So this has helped the product, and the market focus has helped them to make their product much more better. Downsizing, that is cutting your staff if you need to take care of your cash flows. Everything is dependent upon your cash flows. Outsourcing, if in-house is not profitable, probably outsourcing is profitable, and getting some investments from outside. Earlier we talked about the leadership change. We are speaking about the employees which are going out, which are not working properly. Their appraisal report is not good. Probably change them. People with bad communication skills need to be thrown out. Building commitments and capabilities within your processes. If it is a manufacturing company, then proper manpower should be there to handle those manufacturing production capabilities, or the production timeline need to be taken care of. Probably you might have to change the terms and condition of employments of those people. Sales and marketing to be improved, cost reductions, quality improvements, improved responses of customer care, improved information and control system. All these things, when we talk about improved information and control system, we're talking about financial, legal, managerial information that keep on churning within a big organization or a small organization, and having a complete control over those information so that proper decisions can be taken based upon those information. So if you don't have that information, the decision that you take probably would not be right. Lastly, I come to, after doing everything, you should look at financial restructuring, refinancing, or an asset reduction, or getting some more money from some other source. So these are the generic turnaround strategies. But again, the bucket is here, and I like this bucket. When I first thought about this, I mean, it was just, I mean, this is something which is visualized, which you can visualize very well. A bucket with lots of holes, and you have stopped and put some tape on those holes. Your bucket is holding water, and when you have cleared up all the holes, you can put in more money, get more financing into the business, and there would be more profits in the bucket. Now, why should you take a help of a turnaround professional? A turnaround specialist enters a company with a fresh eye and a complete objectivity. When people tell me that they have 40 years of experience and they know everything about that business, I agree with them completely, 100%. But when I get into it and study that, I mean, I can't tell them about their business in a day. I study them about for a month and a half or 2 months, understand the business, and then start advising them, because their system, their financial system, their operational system, their employees, you need to gel with everyone, understand how the business is functioning. Only then you can advise them. Because I am not been a part of the system, I have not been thinking like they are thinking. My thinking would be completely out of the box. It would be completely unbiased. I would have no baggage to take care of. And by baggage, in the sense that There might be some employees who are overbearing on the promoter. There might be some customers. There might be some vendors. There might be some creditors who are overbearing on the promoters. I don't have that baggage with me. I am not emotionally attached with that business. I work on facts, and those facts, and on the basis of those information system and the facts, I take proper decisions. Can advise instantly after analysis and due diligence of the business. Can deal equitably with angry creditors, frightened employees, wary customer, nervous board of directors. So I do not have any baggage to take care of. So when I deal with them, I'm not emotional as the promoter might be. Probably in one of my matters, there was the CFO was the uncle of the promoter, and he couldn't speak in front of him. So when I came into that company, I started arguing with that person on how he's handling the financial aspect. And after arguing with me for half an hour, he said, I'm the uncle of the promoter, so you don't ask me this question. I told him, sorry, it is my duty to ask you all these questions. You have to satisfy me. So these questions could not have been asked by the promoter, but they were asked by me. So if all these things are done, it can really help the business turn around and grow if timely help is taken within those parameters that I've already told you. So when you want to become a turnaround professional, we can provide you with training by international experts. We always look at global certification, so that if you have a certification which is valid globally, you can go anywhere in the world. See, this is not a turnaround profession is not something which is bound by laws. Yes, it is bound by laws in terms of statutory compliances on workouts, on negotiations. Probably there are some laws in different jurisdictions which can help you out on that, but you can always read them, you can always study them, you can always analyze them. There would be court rulings, there would be judgments which you can get some sort of a clarity on those issues. But the management techniques and the accounting techniques are similar across the world. There are a huge amount of turnaround professional globally. So if you are a certified turnaround professional who's globally accredited, I have seen some of them immigrating to Canada, Australia, UK, US, Brazil, Europe, because there is huge amount of requirement of a turnaround professional, because those economies understand the worth of a turnaround professional. It is the same emotion when you meet a doctor who can save a human life. It is similar with a turnaround professional who can save a company from going defunct. Like I said in the beginning, the outlook for 2023 is not very good in terms of growth rates. Even if the growth rate of India has not gone down very much as compared to the other economies, it has come down from 7% to 6.2% growth in the GDP, 6.2% growth. Probably it can come down to 5.8%. But still, those 1% or 1.5% change in the growth rate or decrease in the growth rate would affect thousands of companies. And your presence as a turnaround professional would be a boon for them. So I just come to the end of this presentation, and we can have a question and answer session now.
Participants, open to you.
Sir, can this profession be useful in India too?
Pardon? I didn't get you.
No, turnaround profession, you are saying. It is very much helpful in countries outside India. Will it be also of use in India? I mean, do we get assignments in India too?
Ma'am, if I am correct, if I'm thinking correctly, all the big fours, right? All the big fours like EY, KPMG, PwC, Deloitte. Pardon? They are giving these services to large companies. However, for the MSME section of the sector, which is comprising of almost 98 to 99% of the Indian businesses, there is no one to help them. So when we are talking about 6 crore enterprises, which are individual and partnership, the constitution is partnership or a proprietorship, they are your target customers in terms of turnaround. We're not talking about large companies, we're talking about only of MSMEs, which constitute almost 6 crore MSMEs in India who are not legal entities.
Noted, sir.
Could you please throw some light on what is the exact process one can get accreditation for?
This is something which we are working on right now, but in next couple of months, I believe I would be able to answer that question in affirmative.
Thank you.
Sir, good evening. This is Ramachandran Subramanian from Chennai.
Good evening, sir.
I want to have one small doubt clarified with regard to the operation of a bank guarantee.
Okay.
I am now handling a project in which in the year 2009, the bank guarantees were given for a power project valuated at 995 crores, for which 168.5 crore was a bank guarantee issued by the underwriter. And it was given a very clear date for 4 years. 31st December 2013 was the last date of expiry of the bank guarantee. And in 2013 itself, by September, they have given the commercial operation certificate. That means the client has already agreed that the project is viable for commercial operation. Maybe some last bit of a mile of work might have been pending. And the bank guarantee might have been extended in the year 2013 December by 1 year. But what has happened is these bank guarantees were eventually encashed in December 2021, whopping sum of 168.5 crore. My question is, there has been 2 agreements in between. That means in the year 2015, there has been an agreement superseding the 2009 agreement. And again, in the year 2019, there has been one more agreement.
I have lost you, Mr. Ramachandran. Nitin, can you hear me?
My
Yes,
contention
sir.
is,
I can.
I'm sorry. There was a call and I had to get it. So my contention is, the moment the 2015 agreement came into place, the banker is automatically walking out of the arrangement.
Mr. Ramachandran, I'll just have to stop you here. Your question has lot of conditions, right? and the answer can only be given after seeing all those
Understood
documents.
it very simply.
Right.
No, I understood it very simply that the moment there has been a 2015 agreement, the original guarantee automatically gets novated. The banker is out of the contractual obligation. Am I right?
Mr. Ramachandran, in between I had lost you, but this session is on turnaround. So put me a question on turnaround. The question that you have asked me would entail more questions from me, which would not be right in this forum when all the people are asking about turnarounds.
Okay, no problem. Thank you.
Yes, any more questions? Nitin, if there are no more questions, then we can call it a day.
Sure, sir. Sure. Participants, I mean, last time asking, if you have any questions to be addressed by sir, you can right now ask it.
No, sir, all done.
I think we will be getting this turnaround certification program up and ready within next 2 months. So anybody who would be willing to take up this global certification will be getting 2 certifications. That would be, one would be a global certification, one would be India specific certification. So anyone would wanting to do that, will be helping you out to do those certification program.
Sure, sir, sure. Very nice, sir.
Nitin, so let's call it a day now.
Sure, sir. Sure, sir. I had a query. So can I get it addressed by you right now?
Yeah.
Okay, sir. As you said, there have been prudential framework by RBI. I mean, OTS is also a known fact. It happens at times, and then Section 230 is already there. So,
Yeah.
sir, when legal framework is already there, what do you think has been the reason for the creditors or the debtors not using it effectively?
Number one, it is the initiation is by the creditors, right?
Right.
So like I said, debtor comes to know in the first instance what is his situation. So it has to be a system where the debtor, in consonance with the debtor, the creditor, can initiate some sort of a negotiation. And my only issue being that if it is a contractual agreement, why can't both the parties sit and modify or alter their arrangement, right? When you talk about scheme of arrangement, that is very court intensive and takes a lot of court time, like what an NCLT, the adjudicating authority for that. If we talk about the prudential framework, give anything to the bankers and they would hide behind any sort of a law which they can find, unless they are somehow protected by for their action, for the legitimate and action in good faith. If they're protected by them, then they would be in a much better position to negotiate with the debtors. This is the
Right.
very big issue with the bankers.
Sure, sir. Okay.
Prepacks have not worked.
Right, sir.
Prepack was one area of where the bankers, it was actually designed in a way that bankers could get a code stamp and then done with it, right? But that has not worked very well.
So probably the conditions that are there for the parties to undergo pre-pack, that is not something that is convincing the parties. Maybe.
Yeah. This is the main reason behind that, because one avoidance action and you go directly to CRP, and even being an MSME, you cannot take back that company.
So another thing I recollect now, you expressed a view that regarding developing a habit of banks acting or the financial creditors acting early. So do we need a kind of legal framework, or mere nudging them or persuading them would suffice?
See, I was speaking to one of the EDs in State Bank of India, and I asked her, what stops you from modifying a contractual obligation? And her response was, we follow prudential framework. So they need some sort of a subordinate legislation or a statutory legislation for changing their mindsets to. They want actually a court authority or a legal authority to enforce the fact that they have done the right thing.
Right, sir.
So this mindset needs to be changed. Otherwise, everything is fine.
It's another thing. Last question from my side. So, what do you think? Turnaround, does it work only pre-insolvency, or does it work post-insolvency also?
Post-insolvency, we are seeing in IBC that some companies do turn around. Some companies do get back on track, probably through a sale as a going concern, or through, if it is an MSME, that promoters takes back the company. So, so there are certain instances where this has happened. So it works both ways, and it would be better if it works outside the purview of IBC.
Right, sir.
There would be better recovery options for, or better substantial assets available to the debt creditors, less haircuts for the creditors, probably no haircuts for the creditors, probably the term might increase. Probably there would be 10%. Like I said, spoke about the cost of conflict. So the cost of conflict would be very less in terms if it is done pre-IBC rather than post-IBC.
Sir, this is Ashutosh Mishra. I had one very short question.
Yes, sir.
Is this pre-packaged insolvency process something similar to a rescue or a
It
kind
was
of
supposed to
restructuring?
be. It was supposed to be that it was giving the bankers, the financial creditors, a court-stamped judgment stating and confirming the modification of certain agreements, right? But it has not worked. What is a pre-pack? The creditor comes in with gets into a consultation with the debtor, and they agree on a certain restructured loan agreement, right? And then they go to the court, and the court stamps it and says, okay, I'm fine with it. You both are done and dusted. Now it is your call. But the rules and regulations within that pre-packs have actually not helped pre-packs come up in a big way that it should have come up with. So there should be some changes in the rules and regulations.
That's what I say. In case it's appropriately amended or corrected, then this could be, I mean, since it's within a structured framework of law, this could prove to be a better process, which would have more acceptance.
So what they have done is that they have brought out, I think Mr. Batra, Suman Batra, had given a paper at the IBBI conclave on fast track process, and that has been incorporated within this discussion paper, right? But if you see the way it was given in that paper, given in the IBBI conclave, and the way it has come out in the discussion paper, it is almost a duplication of a pre-pack.
Okay.
Right. So one of my questions was, what is the difference between a fast track and a pre-pack? They're almost similar if you read them, and the intent is always equal. So my observation was that if we want to have a fast track, so why can't we have something on the lines of a standstill agreement, which which I showed you on the workouts, the World Bank principles on workouts. Why can't we have something on these lines where there is minimum involvement of the court, and the debtor and creditor go to the court for a standstill? Even if within 60 days they agree to something, that could be stand by the court. If they do not agree, then both are free to take CRP process or SARFAESI or whatever they want to, whatever legal process they want to get into, they should be free to go into that. But at least give them a chance to work something out without getting into nitty-gritties of legal complications.
True. Thank you.
Sir, this is Venugopal from Hyderabad. Can
Yes,
I
sir.
ask a question, sir?
Sure, sir.
Sir, this turnaround, what you say is out of country. Mostly it is happening, not in India.
No, in India,
Suppose
it's happening.
you said in Canada there are lot many opportunities.
Yes.
In other countries there are lot many opportunities.
Yeah.
So I think the turnaround professional has to be trained for the local laws and acts also, no, sir?
Agreed with you, but understanding law is much more easier, right? If there is a law, you can always read it. You can always analyze it by use of various judgments of the courts, by commentaries on that subject. You can always go through it. You can pass examinations on that. But again, Indian market is so huge that as compared to Europe or Canada or US, it would be a completely gray area as of now in India. So
Yes.
people who have a first mover advantage would be benefiting more. And tell me how many CRP can you do in a couple of years of time?
It's
Probably
bigger, sir.
3 or 4.
Yeah, I did three share figures.
So if you do 3 turnarounds every 2 years, your life is good and happy. And I'm talking about 6 lakh cases at a minimum.
Yeah.
And so the level of satisfaction is to a different level.
Moreover, without any sort of regulations hanging above your head.
Yes, sir. Yes.
So I think that is that it has been a good question and answer session. So let's call it a day now.
Please, yes. Participants, last time asking you, if you have any question, you can get it addressed right now. Right. So I think there are no further questions now. So, sir, thank you very much. For
My
this
pleasure,
session.
Nitin, and thank
And
you all
sir,
participants.
and we look forward to your session on Tuesday, sir.
Okay, thank you.
Right.
Thank you.
Right, sir. Thank you very much.